Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. We all have an idea about the stand taken by senior advocates Mr. Kapil Sibal, Mr. Gopal Subramaniam and Mr. Zafar Shah on the Article 370 matter. The arguments they made were covered in the previous videos. A constitution bench comprising CJI DY Chandrachud, Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Suryakant is hearing the batch of petitions challenging the dilution of Article 370 of the Constitution of India. In this video, we'll discuss the arguments made by senior advocate Dr. Rajeev Dhavan. Before doing that, let's take a few seconds to appreciate the efforts of the team to bring to you legal updates and other news. If you find our content useful, please like and share the videos and also subscribe to our YouTube channel. If there are any suggestions, do let us know in the comment section. Thank you. So coming back to the arguments that were made by Mr. Rajeev Dhavan. To begin with, he asserted in the court that the autonomy of states is fundamental to the Constitution of India. His first line of argument was that Jammu and Kashmir was not the only state which was provided with autonomy, and as per him, autonomy given to states is a fundamental part of the Constitution of India. He argued that the democratization of power was necessary, and without the existence of autonomy given to states and special provisions and concessions given to people when needed, India would collapse. With regard to special provisions, he said that they are regular features and that it was the autonomy within the federation and the special provisions made in relation to people which made the Constitution of India what it was. He said, take that away and we don't need such a big constitution. He also took the bench through different provisions of the Constitution which gave autonomy to various states. He mentioned that there are various articles which provide for special provisions for different states. In addition to this, he highlighted that Articles 239A and 239AA made special governance arrangements for the Union territories of Pondicherry and Delhi respectively. Mr. Dhawan said that India is a diverse country, and emphasizing over the autonomy of states, he said, and I quote, "Our constitution does not shy away from creating autonomous states. Autonomy of states is fundamental to our constitution. Autonomy is not alien to our constitution. To say that special provisions cannot be made in the Constitution is an anathema. These special provisions relate to certain classes. Special provisions are a regular feature of our Constitution." His second line of argument was that Article 370 could only be amended through Article 368. Mr. Dhawan argued that Article 370 applied fully from 1950 to 1957 and J&K Constituent Assembly had the option to amend Article 370. However, the Assembly did not exercise the power to amend the article and was dissolved in the year 1957. Later, after the dissolution of the Assembly, Article 370 Clause 2 and Clause 3 became ineffective and Article 370 Clause 1 survived and remained applicable. He said that as per the same, matters within the instrument of accession required only consultation with the government of J&K, but the application of other provisions of the Indian Constitution under Article 370 Clause 1 were required to follow the mandatory concurrence procedure. He added that to dissolve Article 370, proper procedure to amend the Indian Constitution and then repeal Article 370 was to be followed as per Article 368. This was because Article 370 Clause 1 was an executive power and could not be used to amend the Indian Constitution, which can only be amended through Article 368. He said likewise the power to amend the J&K Constitution also did not lie with the Union, but was inherent in Section 147 of the J&K Constitution, which had previously been used to amend the J&K Constitution. Later, he argued in relation to changes in J&K's territory, which according to his argument required the consent of state legislature. Dr. Dhawan focused on Article 3 of the Constitution and said that it was mandatory for the President to refer to the J&K legislature for its views before passing any bill affecting J&K's territory. He also said that it was mandatory for the President to secure the J&K legislature's positive consent to present the bill in the Parliament. Finally, he argued with context to President's rule, which he said cannot be used to amend mandatory provisions. Dr. Dhawan argued that there were certain conditionalities necessary for the exercise of Article 356. He stated that the same had been established by the Supreme Court in the judgment of M. Nagaraj and others versus Union of India. He stated that as per the same, all the documents concerning the President's rule had to be made publicly available and placed before the Parliament. Contending the same, he said, and I quote, "In this case, even the Governor's report wasn't placed before the Parliament. A full, frank and complete disclosure to the Parliament and the people was necessary. The entire exercise of President's rule needs to be examined. Unfortunately, mandatory requirement of Article 3 was suspended by legislature. It is ultra-virus and taints both the declaration and extension of President's rule in 2018 and 2019. These were a few of the major arguments made by senior advocate Dr. Rajeev Dhavan, which are elaborately defined in the article shown on the screen. To read the detailed arguments, please go to our website, which is www.livelaw.in, and check out the story. Stay tuned to LiveLaw and we'll keep you updated on the case. Thank you for watching.